July the 4th, 2024 is when the UK will hold its general election. In this video, I discuss some of the possible effects of a Labour government on British employment law. The Labour Party stated at the beginning of 2024 that should it win the general election, it would secure a new deal for working people. So for now, let's explore some of Labour's key proposals in this regard. The first of which is simplifying employment status. In terms of employment law in Great Britain, there are three main categories of workers: employees, who are entitled to the greatest of statutory protection; self-employed individuals, who are entitled to fewer statutory protections; and in the middle, the typical non-employed workers, who are often self-employed but nonetheless have protections by some significant statutory protection, albeit not as much as employees. For instance, they currently aren't entitled to statutory sick pay or protection against unfair dismissal. The removal of the distinction in employment law between employees and these intermediate categories of workers, and the status of workers for all but the genuinely self-employed, are, it would appear, central to Labour's New Deal proposals. The second key proposal are day one rights. So one of the main points of Labour's proposals that raised eyebrows across the employment law profession was the proposal to provide protection for all workers from the time that they start working, day one. This might include, amongst other things, the right to receive sick pay, parental leave, and indeed compensation, and the prohibition against unfair dismissal. Unfair dismissal itself, subject to certain exceptions, is generally for employers who have been working for the employer for at least 2 years, and this covers across the board most employees. As there's always been some kind of threshold for unfair dismissal of some duration, these day one rights would be a significant shift in employment law. Although recently this is likely to be under some kind of revised plan, but we will see what Labour actually does. It's unclear whether there will be some kind of provision for unfair dismissal and these day one rights if it is in the probation period, for example. Labour has further stated that it would remove the cap on compensation for unfair dismissal claims, and that would guarantee that employers would receive full compensation, as it were, should they suffer loss owing to employers' breaches of the law. Labour currently argues that the caps are unfair and discourage companies from following the law. Labour also say that they will increase the amount of time that workers have to file claims with employment tribunals. Currently, for the majority of employment law claims, the limitation period, or the amount of time that employers would have, is 3 months, and it seems to be the case that Labour intend to increase that to at least 6 months. Watch this space. The third key proposal is a proposal to improve disability, gender and ethnicity pay gaps. The proposed deal also calls for mandatory ethnicity pay reporting for companies with more than 250 employees, as well as requiring employers to implement plans to eliminate the gender pay gap, which is currently voluntary. Recently, Labour announced that it would expand the grounds for equal pay claims as well, beyond sex, to include claims for disability as well as ethnicity. To add to this, Labour's current proposals include mandatory requirements and enforcement, rather than just mere requirement to publish this data. The next key proposal concerns flexible working rights from day one. Now, let's discuss this. Making this a day one right. Currently, it's the case that an employee has a right to request flexible working from day one, but not the right to work flexibly from day one. Labour seeks to flip the script on this to allow employees to work flexibly by default from day one, with employers required to allow this where reasonably possible. Another key proposal is that they seek to make stronger collective bargaining rights and also to reform trade union laws. So Labour has declared its intention to empower working people to collectively seek fair pay, terms and conditions given its long history of ties with trade unions. It isn't clear exactly how they'll accomplish this though, as it's currently withholding its plans, so we'll have to watch this space too. One reform that Labour has announced is the implementation of fair pay agreements, which would establish minimum requirements for entire sectors and allow this bargaining across the board. The next key proposal that Labour proposes is to end the practice of fire and rehire. This is where companies may fire workers and then quickly rehire them under less favourable terms. This is, believe it or not, more common than one may appreciate. So this would further solidify an employee's role within companies. The next key proposal that Labour intend to bring is the right to switch off. Labour claims that with some of the longest working hours in Europe, the UK has a culture of long hours. The rising number of workers working from home and the development of technology, which means that workers are no longer necessarily in the office at the end of the day, may be a contributing factor to this. So in an effort to better balance work and personal life, Labour's first proposal for this is for employers to give employees the right to disconnect and not contact them outside working hours. This is not the first time it's been introduced in Europe. France set the precedent in 2017. Ireland, Germany, Italy, Belgium, Denmark, to name a few, have since followed. On the other hand, any firm proposal would indeed have its own obstacles, I would suggest. It does seem that Labour are trying to figure out the best way to implement this, and there are currently rumours that this right may be introduced through an ACAS code of practice, and there may be an exemption for smaller companies, rather than implementing it through new legislation. There are some genuine considerations to be made with this change. For example, how does this work with flexible working? And how do you make this work across different industries? And certainly those if one is working across international borders or time zones. So to round up, it's worth bearing in mind that the Labour Party have promised to implement these changes within 100 days of assuming office. We are unsure about how this would actually work in practice though, including whether this includes consultation periods, for example, within that 100 days, or if their goal would be to pass this goal within that 100 days. A key question: how can employers prepare for a Labour government? It could be that there are too many unknowns for employers to begin acting immediately and get ready for these changes, given that the election outcome hasn't indeed taken place yet, and any proposals would need to go through a legislative and consultation process, unless employers could be well advised for these steps that I'm about to mention. Firstly, if you don't have an annual employment law retainer, get one. Magaralaw, for example, offers this service, and you can find the link for this in our description below for this video. Essentially, what this is, for Magaralaw, is employment law advice unlimited, subject to a few exceptions, in exchange for a set annual fee. The value is priceless. If having an employment solicitor on your side, without there being the stereotypical hourly rates, is something that's important to you, genuinely consider this. Next, employers ought to consider who may be entitled to some of these proposed steps to come within the organisation. That includes figuring out who are the genuinely, as it were, self-employed, those who may be bunched up as workers being employed, as well as their current workers. Employers will also benefit from having a better understanding of the financial effect of these reforms beforehand. They will need to practically seek to ascertain any current issues within their workforce. And to give some kind of idea, this means that employers need to assess and deal with any issues, for example, harassment, intimidation, or any other broader issues related to diversity and inclusion, firing, rehiring, recruiting, as well as cultural concerns within the workforce. There are plenty of other things that employers can do, but these are just a few. So thanks for watching this video. Leave a comment with any thoughts, comments, questions, complaints or otherwise. You're welcome to like and subscribe in order to get new videos as and when they come up. It's worth just me highlighting that this video is not legal advice, it's general thought process and certainly my opinion on some of the proposals to come. For employment law advice, you are welcome to call Magaralaw on 01869 325 883 or email me, Roy Magara, at roy@magaralaw.co.uk, and the details also are in this description. Thanks.